What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Wednesday. Happy hump day. Hope you guys all had a great day. We've got some interesting cases tonight. First one, this guy named George Kelly. I don't know if you guys have been paying attention to this story. This clip was about a week ago that I'm about to show you. Now, it's a very interesting story, and I tried to figure out the best way I could summarize it for everyone who hasn't watched it. So, but I did, while I was doing research to try to put a little script together to explain it, I did find a video that's about 2 minutes long. So I'm going to share that before I play the clip. And I do have the link to the video, to their video and their channel below. But it's an interesting story. Like, I'm just going to say this 75-year-old, you got the nickname as Machine Gun Kelly, just to kind of spoil a little bit for you. But then after that, I've got, my normal stuff, normal random courtness. But courtness, I just made up a word. All right, you guys are all awesome. Thank you for being here. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. Oh, wait, I gotta play the clip first. You know what? I'm gonna play the first half of the video and then play the clip. No, I gotta summarize it first. All right, hold on. Let's get this. All right, so here he is in court, but here is the summary of this guy. Let's go.
Information you provided here is the truth and nothing but the truth, so help you God.
Yes, Your Honor.
The man in the orange jumpsuit, 74-year-old George Allen Kelly, an Arizona rancher charged with first-degree murder in the shooting death of a Mexican national on Kelly's 100-acre ranch along the U.S.-Mexico border.
It's alleged that on or about the 30th day of January of 2023, intending or knowing that this conduct would cause death with premeditation, did cause the death of the victim with the initials of GCB.
The victim is this man, 48-year-old Gabriel Quinn Butamea of Nogales, Mexico, identified by the voter registration card he was carrying. According to court documents obtained by News Nation, Kelly had returned home to eat lunch with his wife after finishing chores. As they were eating, they heard a single gunshot and saw a group of men moving through the trees. Kelly's attorney writes, they were armed with AK-47 rifles, dressed in khakis and camouflaged clothing, and carrying large backpacks. None of them were known to him. He had not given any of them permission to come onto his land. Reportedly scared for his family's safety, Kelly carried his rifle onto the front porch and confronted the men.
Yeah, no political talk. No political talk. All I'm doing is giving you a quick summary of what happened to this guy. Or what happened to this guy? What the story, the George Machine Gun Kelly story, and then I'm gonna play his latest clip in court because I was really interested in the case and I'm amazed that I actually found the clip. So yeah, let's go. Yeah, no politics. We're a political free channel for the most part.
Who allegedly pointed an AK-47 at him. Kelly's attorney says he fired off warning shots high overhead to scare them off, and they fled. After calling the U.S. Border Patrol Ranch Liaison, which aids those living along the border, sheriff's deputies and Border Patrol agents scoured the land and its cameras, but didn't find any trespassers. Hours later at sunset, Kelly found the unarmed body of a man, now known to be Quinn Butamea, outside in his pasture. Arizona is a stand-your-ground state, but Kelly's team maintains he did not shoot directly at anyone. Tonight, Kelly remains in jail with $1 million bond. Calls to release the 74-year-old and drop charges are growing. This Change.org petition has garnered nearly 10,000 signatures, and multiple fundraisers have brought in more than $300,000 in support of Kelly.
All right, so that's kind of the quick summary. Now this little 2-minute clip, thank you News Nation, by the way. Their link is in the description if you want to check out more of them. But hold on, I'm going to bring this up and pause it. So that was about a year ago. Now, since then, so he did get out on bond. So he had a bunch of, charities and GoFundMe type of things going on. He actually got out on bond, but he did an interview, and that's if you just put in George Kelly into Google or YouTube, you'll see the interview, and it's actually a really good interview. And it kind of breaks down his side of the story. But this is a case that I don't really believe fully either side. I feel like the defense was hiding something. I feel like the prosecutor was hiding something. The whole story didn't really make a lot of sense. So yeah, so he was found not guilty. No, it was a mistrial. It was a mistrial. They had, I don't remember how many jurors. I think there were 12 jurors. I think it was a full jury. So I think there were 12, and 11 of them found him not guilty, and one of them found him guilty. So it was a mistrial. So this is the hearing after the trial. So he's set free. He had the interview, which you guys can all go look up and see. But this is the hearing. All right, let's go. I think everyone's caught up. We're on the same page now.
On the state's motion to dismiss this case without prejudice, there's an objection from the defense seeking a dismissal with prejudice. The motion is the state's, so I'll hear first from the state. Ms. Humley.
Thank you, Your Honor. Your Honor, Rule 16.6 requires that a dismissal be without prejudice, absent a finding that the interests of justice require it to be with prejudice. Case law, State versus Gilbert and State versus Wills, which are cited in the...
Yes. So a hung jury means a mistrial. So a hung jury just means they didn't come to a unanimous decision. So they'll come out. The judge will send them back as many times as he wants to. But and then after so many times, they'll declare a mistrial. So a hung jury just means the jury has been deliberating for hours upon hours, days upon days, and they don't have a unanimous decision. So that's what a hung jury is. And a mistrial happens because of a hung jury. Well, one of the reasons mistrial. There's 1,000 reasons a mistrial can happen, but a hung jury is a cause for a mistrial.
State's brief indicate that articulable prejudice is required, and that what does not constitute articulable prejudice would be things like annoyance, inconvenience, wanting finality in the decision, and even incarceration, according to the Gilbert decision, is insufficient. Here, there are a number of factors that may change the state's case in the future. The defendant has already made one statement to the media post-trial. Should the defendant continue to make statements to the media or write a book, which he has written about a book in the past, those are things that may change the state's case and whether we're able to proceed going forward. In addition, unknown witnesses may come forward. Known witnesses who we have been unable to reach because they're in Mexico may become available. That includes RFG and Miguel. And the political situation may change, and that may change the attitudes of jurors. In addition, Your Honor, I believe a significant factor in this case was the lack of peremptory strikes. And that's another factor that the state believes could impact whether we can try the case again in the future. The defense cites the case of State versus Huffman that indicates that the court may balance the interests of the defendants against the interests of the state in determining whether the interests of justice require dismissal with or without prejudice. That case actually involves a case where there were two hung juries, and it was following the second hung jury that the defense filed a motion to dismiss the case with prejudice. And the court found even in that situation that there was not a requirement for a dismissal with prejudice in that case. And the appellate court upheld the trial court's decision that even a third retrial did not constitute a problem in terms of there being a requirement for a dismissal with prejudice, and that the interest of justice requiring that dismissal. In balancing the interests, there are some things that the court should consider. First, Rule 16.6 no longer contains the language that is in the Huffman decision, requiring the court to balance those interests. Also, the defense cites financial concerns as one of the reasons why the court should not allow a retrial in this case. According to an article in the Arizona Republic on March 23rd of 2023, a Christian fundraising site called Give, Send, Go raised $425,000 for Mr. Kelly related to this case. So I don't believe that financial concerns should be considered by the court. The state also disagrees with the defense's characterization of there being a lack of evidence in this case. The court sat through this entire trial and denied a Rule 20 motion. Clearly, there was significant evidence in this case to warrant a conviction. We have the defendant's admissions to shooting, the position of the body, the direction from where the defendant would have shot, defendant's statements, specifically those statements to 911, the defendant's wife's statements that she believed the victims didn't intend any harm and they were just walking by. And the only remaining fact is that these folks are elderly and that a pending trial could cause them anxiety. Balancing that against the state's interests in convicting someone for second-degree murder, the state believes that the balance of those interests require that this case be dismissed without prejudice. Thank you, Your Honor.
Thank you. Ms. Larkin.
Yes, Judge. Your Honor, the legal standard here is that this is a discretionary decision, so it's up to the court, in the court's discretion, what to do here. But that decision is supposed to be informed by the particular circumstances of the case. That's what all the case law seems to indicate. And the court has to make specific findings in this case that the interests of justice require that the case be dismissed with prejudice if the court is going to order that it be dismissed with prejudice. We believe that the particular circumstances in this case are such that this case does warrant a dismissal with prejudice. Reason number one being that there's no statute of limitations for homicide cases, meaning there is no other possible way for Wanda and Alan to get the repose that they need here. At the very beginning of this case, both the investigators and the prosecution had choices that they could make. One choice is they could investigate this charge thoroughly first, fully prepare their case, find their witnesses, vet them, and then charge the case and then go forward. Or they could charge the case first and then essentially just cobble together an investigation while the case was proceeding through court. And that's what they did. They went with option 2 there. And we believe the interests of justice require dismissal with prejudice because the state, after making a choice like that, they shouldn't be permitted to essentially perfect their case after they give it the first run through and then they can see all the issues that they have with it. They shouldn't be able to fix it later in the future. They shouldn't be permitted to just essentially try to basically railroad somebody by pushing this through very quickly and then fix everything when it doesn't work out the first time. The evidence that the state presented in this case also mitigates, I think, against trying this again or for a dismissal with prejudice. They had one witness in this case who claimed to be the sole witness to these events. The state is claiming that that one witness that they put on was truthful and that what he said happened is what happened in this case. It's strange to consider that the state would then believe that other witnesses might potentially come forward and be telling the truth. They put on one witness. Their assertion is that witness was telling the truth and that that was the only witness to these events. So any other witness who could potentially come forward is automatically going to have serious credibility problems, as they should. And it's not appropriate to permit the state to essentially just fish for additional witnesses if the first one wasn't good enough, the first one who claimed to be the only one. In the state's motion, they made some claims about having issues finding or contacting or communicating with witnesses because the witnesses are residents of Mexico. But in this case, as the court's well aware, the Mexican consulate was very involved.
Just a quick 10-second summary. This guy was accused of shooting somebody on his property, and his story was he shot in the air. He saw people run into his yard. He lives in, is it Arizona, I think? And he saw people run through his yard earlier in the day. He confronted them. They left. They fled. But he shot in the air to get their attention before he, confronted them. He called the police. The police came over. They didn't find anything. And then, like 8 hours later, they found a body on his property. That's the story. That's the story that, at least that's his side of the story. Let's say that. But yeah, there's a huge case. Just Google and even in YouTube, just George Kelly is this guy's name. They even call him Machine Gun Kelly, which is kind of funny. I mean, ironic, kind of funny, not haha kind of funny, I guess. All right, let's go.
In the beginning, the family members of the deceased person also very involved, very communicative with the state. The state could have elected to put on family members to present some additional evidence that they consider to be relevant. They chose not to do that. The state was able to communicate with their main witness, Daniel. The state provided that witness with a phone. They paid for it, that witness then used to communicate with the state. He was escorted to and from court. His accommodations were paid for by the state. And we even had the sheriff getting involved in this investigation, traveling into Mexico to conduct criminal investigations in Mexico. And so I think the argument that the state makes in their motion about having difficulties because these witnesses reside in Mexico just falls flat given what they were able to present in this case. And we would also just cite that the state was provided with a full opportunity to present all of their evidence. We had a month-long jury trial. We had the jury go out to visit the scene. We had witnesses come in from foreign countries. We had experts come in from all over the country to testify in this case. And the state had the benefit of a number of favorable pre-trial evidentiary rulings. In this case, they did everything that they could to obtain a conviction, and they simply couldn't do it, and it was by such a close margin. As far as articulable prejudice to the defendant, Judge, in this specific case, the public nature of this case has absolutely destroyed any integrity of any investigation that would go forward in the future. Anybody can just study the case, look at the area, and they can come forward and claim to be a witness.
You have that backwards, Allie. He was found not guilty by 11 and guilty by 1. At least that's how I remember it. If I said that wrong, if I said it backwards at the beginning of the video, I'm sorry, Allie. But no, you have it backwards. He was found not guilty by most and guilty by 1 or 2. I think they say that during this video, actually.
And in this case, provide information that's essentially accurate and unable to be tested because all of the information about this case is already out there. There were false reports that were made in this case, and those have essentially been brushed off. And those false reports were able to be discovered because the people who were making the reports reported things that were contradicted very clearly and completely by the physical evidence in the case. Now that everybody's aware of what that physical evidence is, anybody who comes forward is likely to be more credible, even if they are making a false report, and that's serious prejudice to the defendant. A second trial would be prohibitively expensive for the defendant. The state talks about give, send, go, and they were able to raise a bunch of money. They had to pay $100,000 in cash just to post the $1 million surety bond, and that money is gone. They had to contact experts. We had to have that assistance. They had to have multiple lawyers who were working on this case and sitting through a very lengthy trial. That's expensive, Judge, and that is prejudice to the defendant. We also have, for the defense, the only witnesses are essentially Mr. Kelly and his wife, and these are elderly witnesses, and their memories are failing as time goes by, and that makes a big difference. Their health is also failing as time goes by. The state mentioned if Alan decides to even talk to anybody about this case and they discover it, they could try to pick out some additional inconsistencies or something like that. And that's a serious prejudice to the defendant. It would mean he and his wife essentially would never be able to talk about this until the day that they died. There is no statute of limitations. The trauma that these two experienced by going through this process was huge, and the trauma, if there was to be a possibility that this case could come back, would be even greater. If they have to worry about a political situation changing, and that might cause the state to bring the exact same case back again, that's not right. That's severe prejudice to the defendant. And I think the court has to weigh all of this against the likelihood of the state actually succeeding in a somehow future conviction. And they just don't have a very high likelihood of finding a unanimous jury to look at this evidence and say that this person's guilty. The last issue.
Big N, thank you so much for the raid. I appreciate it. It's 2 nights in a row, man. I appreciate the love. I appreciate the love. That is awesome. And welcome to all the raiders. Just a really quick summary. This is George Kelly. He was accused and charged with shooting somebody that was on his property. And it's a wild story. I don't know if I can recap it again. I've already recapped it a couple times. The best I'm going to tell you to do is Google George Kelly. That'll be the best way you can do it. Or just type his name into YouTube. Obviously after my video is over. But so this guy was accused of shooting someone that was on his property. He was charged with homicide, I believe. And it's a wild case. It's a wild case. And this is so. He went to jury trial. He was found. I keep saying that. I keep trying to say he was found not guilty. He wasn't found not guilty. It was a hung jury. There was a mistrial. So this is the defense trying to argue that the case should be dismissed with prejudice. So that's what this hearing's about. It should be dismissed with prejudice. So the state shouldn't be able to refile this case and come back at him again. So that's where we're at right now. This is almost the end of the clip, though, so we're about to get back to the normal stuff. This is just a kind of like a hobby case I've been following. I just found this really interesting.
I think the court needs to consider is to the composition of the jury in this case. As the court's aware, there were 7 jurors who voted to acquit Mr. Kelly on everything, and there was one person, and one person only, who said that he was guilty. And that's the whole reason we're here. This was not a close case by any stretch of the imagination. This case could not have gone worse for the state in this case other than having a full acquittal of Mr. Kelly. And this case was just so close that allowing the state to try to fix their evidence and go forward with the integrity of any future investigation so thoroughly compromised is massive prejudice to the defendant. And to conclude, I would just say that if the prosecution is going to prosecute first and investigate later, there should be consequences for that. The state was aware that their evidence was lacking. The state is still aware that their evidence is lacking. And it's not right to incentivize that kind of, charge ahead type of prosecutorial and investigative conduct. They had their shot. We put the jury through a very long and intense trial, put Mr. Kelly and his wife through a very long and intense trial, and we believe this should be dismissed with prejudice. And if Your Honor does dismiss with prejudice, we would ask that Mr. Kelly's remaining property that's in evidence be released to him.
Thank you, Ms. Larkin. Does the state wish to reply?
Yes, Your Honor, thank you. Your Honor, the statute allows specifically this. If there is one juror, the statute permits a retrial. That's exactly how the law works. So that should not be considered one way or the other in deciding whether this should be with or without prejudice. There was a mistrial in this case. The state is entitled to retrial. The state has decided that at this time it's not appropriate to retry the case based on a number of factors unique to this case. One of which is one of the witnesses performed very poorly, or more than one of the witnesses performed very poorly during the trial, and that caused some credibility concerns for the jury. without additional information, given that that occurred during this trial, the state's not prepared to go forward at this time with that same evidence before a jury and with those same witnesses. The defense claims that there are serious credibility concerns if other witnesses do come forward later, because they claim that witnesses could tailor their statements to information that they saw in the media. The defense can impeach on that basis, given a further trial. So there's no prejudice to the defendant from that. The defense could absolutely impeach on that issue. So there is no legal prejudice on the basis of that. In addition, the defense claims that all witnesses that come forward later have significant credibility concerns because the state's position has been that Daniel was the only one there with Gabriel at the time of the homicide. However, throughout this trial, it's been the defense's position that Daniel was an unreliable witness, that he was lying, and they even insinuated that he's the one that murdered Gabriel. So that doesn't jive with their position throughout the entire trial. The fact that the Mexican consulate is involved in this case doesn't mean that the state has the capability of locating and forcing witnesses to trial who are Mexican citizens. If those witnesses do later come forward and indicate that they're willing to come to trial, the state may be in an entirely different position than we are today with respect to our case. Most importantly and most concerning is that the defendant has already started to go on the interview circuit regarding this case. If the defendant were to make statements indicating admissions to this case, further admissions in this case, or make statements that are contrary to other statements he's made in this case, it would also significantly change the state's position and perhaps allow a retrial. The fact that they can't talk about the case, that's exactly the issue that the state is concerned about, Your Honor, that they are going to talk about the case, that they're going to make statements that incriminate the defendant further, and the state's going to have no ability to do anything about it. And I think weighing those interests in this case, Your Honor, makes it clear that the higher interest in this case is to dismiss this case without prejudice. Thank you.
Thank you, counsel. The matter is submitted. The court will take the matter under advisement and issue a written ruling. So is there anything further? We're adjourned on that matter. Thank you.
Thank you, Judge. May I be excused?
Oh, Your Honor, there is one issue. We did just have a further request with respect to evidence in our motion that will go along with your ruling, but just wanted to put that in the court's mind.
What was it?
There are some items that are in the court's evidence that should the court determine that the case is dismissed without prejudice, we'd ask that those not be released.
Okay, understood. All right, thank you. We're adjourned on that matter. Thank you, counsel.
All right, I'm not going to comment too much about that because this is a very highly politically motivated case. It was a hobby case of mine. I was following it. It's about a year old now. That clip happened a week ago, so I've been looking for whatever the ruling is that the judge decides. Judge Fink. It's not Magistrate Fink out of Michigan. It's Judge Fink, and I believe it's Arizona. Anyways, again, now that I can actually pause and talk freely, thank you so much again, Biggin, for the raid. You are awesome as always. If one of my mods can drop his link, I would appreciate it. Even though you all just came from there, everyone's members over there or subscribers over there. Everyone loves Biggin. I love Biggin. All right, let me get through some of these. Cross, thank you so much for being a member for 3 months. Hi, all, Colin. Hope you're doing well today. I am doing well today. Thank you so much, Cross, for being a member for 3 months. I appreciate it, bud. Rose D, a new member. Thank you so much, Rose D. Welcome to the family. I appreciate it. Legal Fiction dropped 20 last night, dropping 10 tonight. Thank you so much, Legal Fiction. I appreciate it, bud. Thank you so much for the 10 gifted memberships, and welcome to the new 10 members. You guys are all awesome. Thank you so much, Legal Fiction. And Bradley Webb gifted 1 membership. Thank you so much, Bradley. I appreciate the 1 gifted membership. Thank you so much, bud. All right. All right, now let's get to the regular scheduled program. You know, random court stuff where we can sometimes laugh at, sometimes cringe at, and then sometimes yell at. So got that one out of the way. I wanted to share that. I've been looking for a good time to place that video. And like I said, I watched it a week ago, and it's like I didn't know when to place it, but I wanted to share that case with everybody. It's a very interesting case, and thank you to the chat for not making it political. I appreciate everybody. I don't think I saw any political comments in there. All right, let's keep going. I don't even know what I have now. What are we going?
Covina
Oh, this one's fun.
Plaza versus a Michael.
Covina Plaza on Zoom.
All right. Go ahead and get us started. Covina, what is the monthly rent?
Monthly rent for the unit is $725 with no housing subsidy.
Okay. What is the total amount that you're seeking in back rent?
So we are not seeking anything in rent. We are seeking for possession of the unit.
All right. And I see that there is lease violations, something about a gun being fired. Is that correct?
Yes, ma'am.
Correct. I have reports, multiple reports, police reports, as well as tenant complaints.
So, Your Honor, I hired a defense attorney to fight these charges, and they've been looking into it. I have no arrest warrant. There's no open case on me. There's nothing at all. I literally spent $4,000 to pay a defense lawyer to fight these charges because she's trying to say I unlawfully discharged my firearm. I did no such thing. There was no reports. Know what report she's talking about. The police that I talked to, my lawyers that I talked to said that there's no investigation, there's no warrant for my arrest, there's nothing. And I spent $4,000 for them basically to tell me that there's nothing. Now, I do possess a firearm. I'm well within my right to do that, but I do not brandish it wildly. She's making it seem like I just go out here and I'm just brandishing my gun and I'm just flashing at the people and I'm shooting it. Now, again, it's unlawful discharge, which means I shot my gun. No shell casings, no evidence. I literally have my gun at home waiting for someone to take it to test it, to show that since I bought it, I haven't even taken it to a gun range to shoot it yet, ma'am.
So what are you saying that it's going off? Are you discharging it?
No, I haven't done anything.
So why did you say you were discharging it with no
they're
warrant?
saying I discharged my firearm.
And I also got about 4 or 5 tenants writing in letters that are swearing to this as well.
It's false. I
Right.
have videos.
Hold on, Michael.
Not only that, but we've just had Mr. Michael running around property, or not necessarily running, but yelling out, I'm gonna kill. And it's just become an issue to where my residents are afraid of him. So we don't want any problems. If he can just give us possession back of the unit, then we're fine. I'm willing to dismiss the decision if he moves out by the end of his lease date, which is June 20th of this year.
July.
I have the lease here and it ends June 20th of 2024.
6/20/24, 6/20. My lease on my phone from the PDF file says 7/20.
I don't know what your lease says. I mean, but at this point, Mr. Michael, I have enough evidence to proceed forward. So my question to you is, how quickly can you move out?
I need time.
Because if I grant it, you've got 5 days.
I've been speaking.
Yeah, Paul, that's actually funny. I thought that was the manager at first. Yeah, she is sideways staring at the screen in the dark. Yeah, no, she is working on a Zoom court horror flick. That's funny. I laughed at that. While I am paused, not I always say not a number every single time I see your name. Thank you so much for the 4 months. It does seem like so much longer, but thank you so much. My favorite not a number, Nan. And Mark, thank you so much for the 10 gifted memberships. That is extremely generous. Thank you so much, Mark. I appreciate it. And welcome to all the new members. All right, let's keep going. Thanks, Mark. Thanks, Nan.
To people to help me as far as like renters and stuff like that, and they're all telling me the same thing. With this thing going on, again, there's no proof, Your Honor. There's no proof besides hearsay.
I have an SAPD report and I have 4 witnesses' testimonies. I understand that there's no proof, but they have met their burden of proof when I have all these signatures, and I have an SAPD police report.
That's what I'm saying. There was no police report that my lawyers found.
I have an SAPD report You can give this to your attorney if you like.
Yes, ma'am.
It's public record. You can go purchase it outside in the front.
Okay.
Okay, but I have a police report. It is right here. Okay, so I have to proceed forward with the police report. Not only that, I have 4 or 5 tenant signatures.
Who are these tenants, man? Because it's
I'm
like,
not gonna
okay, that's
disclose
right.
those tenants.
But I
Are
don't,
you
I don't,
crazy?
I don't have issues with my neighbors. I literally have like people like I go to church with one of the ladies that live there.
I got 1, I got 2, I got 3.
I literally, there was another man that passed away not too long ago. That used to like, I used to take my dog to go visit him. I don't have problems with people, man. I don't understand why I'm going through all this. All I do is pay my, I've never missed a day of rent. I pay my bills on time. I don't understand all of a sudden, and I have reports of dog issues, like random dogs trying to attack me. This all started because I tried to protect myself against a dog attacking me and my dog.
Okay. I got text messages of tenants stating that they're scared. So unfortunately, they have met their burden of proof. Okay. So
Your
Mr.
Honor, I'm willing to dismiss judgment if he moves out within the time frame so that this eviction does not go on his record.
I need time. I spoke to the property people finders, and they told me that they can help me, but the problem is that if Christina says the things she says or throws this out there, that I can't find anything.
So how much time do you need?
I've got some of my stuff packed. I need to find a place.
How much time do you need?
30 days, honestly.
Okay.
I need
Covina, are you willing to give them 30 days or are you seeking judgment today?
I'm seeking judgment today. I can wait for 2 weeks, but that's it.
All right. So unfortunately, Mr. Michael, I have to proceed forward. So judgment is going to be for possession only. You've got 5 days to move out or appeal it. According to landlord, she's giving you to 2 weeks, but she's not giving you any more than that. All right, so judgment for possession. Again, you've got 5 days to move out or appeal.
Thank you, Your Honor.
Thank you. All right, let me get.
All right, 2 things. First thing, it is crazy that Texas is a 5-day rule. Once you go to court, you have 5 days to move. 5 days. That is not enough time to find a place. I mean, potentially you could, secure a place in 5 days, but I mean, especially if it's the middle of the month. I mean, you'd have to. Yeah, that's such a difficult rule. I know Michigan's 10 days once they get the judgment, but but in Michigan it takes a long time. Like you have 2 or 3 court dates before they give you the 10-day notice. Maybe that's his 3rd appearance. I don't know. But second thing, Terry Lynn, thank you so much for the PayPal. That is awesome. I appreciate it. And you rock, Terry Lynn. You rock. Thank you so much for the PayPal. I appreciate it. All right, next case. You guys are all awesome. Thank you for hanging out.
Josue Carvajal. Good morning. Good morning. Are y'all prepared to proceed on the motion to revoke? All right. Court is calling 2022 CR 5498W, State of Texas versus Josue Carvajal. Can I have parties announced for the record for the state? Defense?
Efrain Torres Jr. for Mr. Carvajal.
And are you Mr. Carvajal?
Yes, ma'am.
Did you review the document entitled motion?
Oh, it's always 5 days. From the day that there's a judgment, it's 5 days. 5 days to move. That's what it is in Texas. I've watched that court enough to know that that's just across the board. Now, sometimes they get adjourned for one reason or another. But yeah, that guy came in fighting. He didn't think he was going to lose today. He came in fighting, and he has 5 days to move. If he's doing what they're accusing him of doing, then that's on him. But he was saying none of this is true. There's nothing going on. Whatever. 5 days just seems kind of bad. I think the landlord did say that they were giving him till the middle of the month, though. So I think they said they gave him till the 15th. They gave him more than 5 days, if I remember that right. I might be crossing cases. All right, Judge Boyd, let's go.
Motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney. And did you understand it?
Yes, ma'am, I did.
Are you the same Josue Carvajal who's placed on deferred adjudication in 2022 CR 5498W for the offense of unauthorized use of a vehicle on June 7, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. On the supplemental, motion.
For the people that just walked in, my name is Joe. I'm with the City of San Antonio Housing Department.
Carvajal did
The
this.
city right now does have relocation assistance available. So after you speak to the judge, talk privately in this room over here.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, will waive any kind of condition.
Any objections to the state's waivers? UCR 5498W, State of Texas versus Josue Carvajal. Can I have parties announced for the record for the state?
Casey Garrett, Your Honor.
Defense?
Efrain Torres Jr. for Mr. Carvajal.
And are you Mr. Carvajal?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? And did you understand it?
Yes, ma'am, I did.
Are you the same Josue Carvajal who's placed on deferred adjudication in 2022 CR 5498W for the offense of unauthorized use of a vehicle on June 7, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. On the supplemental, motion, Your Honor, violated condition number 4, in Bexar County, Texas, the defendant, Jose Carvajal, did it in there, failed to report to the supervision officer as directed for the months of March 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, will waive any kind of condition.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and that is to grant the motion and revoke the individual from his probation to sentence him to 180 days in the Bexar County, in the state jail facility.
All right. Counsel, are you asking the court to follow that agreement?
Please.
So what has he done on probation?
Judge, I believe he's completed IOP. I also believe he's paid about $1,000 towards his fees, Judge. The rest of it was not able to be complete, Judge. I believe Mr. Carvajal can explain it to you if you wish.
All right. Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Josue Carvajal Isaiah.
Why didn't you report in March?
I did not report in March because I was having, honesty. There's family, basically my grandfather was dying. He was gonna be no longer here, and I wasn't there with my father, and it was just too much for me. I couldn't come and.
Oh, did you pick up the phone and call probation and said, my grandfather is dying, I can't come in?
Yes, ma'am, I did.
Oh, wait a minute, do we have proof of this? Ms. Abrams, he said he called probation and said he can't come in, his grandfather is dying.
Judge, I'd have to take a moment to review all of the photos.
All right, here's a pro tip. If you're ever a defendant in court, never make a statement that it can be easily proven. Just don't do it. I mean, you're just gonna make yourself look bad. I don't know. I don't remember if he's lying about that or not. I don't think it actually comes up again, but yeah, that can be easily proven. It can be easily proven. All right, retired Rachel, thank you so much for the $4 super sticker. I appreciate it. Thank you so much, retired Rachel. I hope you're doing. I hope you're having an amazing evening, and thanks for watching. Also, Heather, good to see you. Hope you're having a great night as well.
All right. So you're saying you called them?
Did you call him or you left the voice?
I left the voicemail.
Oh, okay. So they should have a voicemail if you left it. And is there anything else you wish to say?
And as well, I became a father at a very young age, ma'am. I just wanted to get this out of there. I became a father at a very young age. I have children of 1, 2, and 3-year-olds, and it's they have been basically they've been my main priority, and I know it as well. Probation has had to be one of my main priorities, but I couldn't balance both out. So I felt deeply at completing my probation.
Okay, so you have a 1, 2, and 3-year-old. That's what you're telling me.
Yes,
And how old are you?
20, ma'am.
All right, so why would you're 20 years old, you have a criminal case for unauthorized use of a vehicle. At some point in time, you continue to have children, even though you were on probation. Why are you doing this to your children?
Well, 2 are I have taken them onto my wing, and one of them is mine.
So there's a mother out there who wants you to take her 2 children under your wing, knowing that you have criminal history.
Yes, ma'am.
And then she has a 2-year-old and a 3-year-old. Are the 2-year-old and 3-year-old your biological children?
No, ma'am.
All right, so she has a 2-year-old and a 3-year-old, and then she decides to choose you to have another child. So now you all have a 1, 2, and 3-year-old in the house. I don't understand why people are making these what appears to be horrendous decisions. Children are a blessing, but children are expensive.
Yes.
And probation is looking to see if you actually called, because this is not your first time before the court on a motion to revoke.
Correct.
And so I'm just trying to figure out whether or not I'm going to give you what you're asking for or going to give you something more.
There was a telephone call stated that he had COVID and he wanted to schedule. That was on March 8th.
I believe that was a mixture of both. I think his grandfather was already ill and passing away, and he was also ill himself.
Yeah, he didn't say that. When I questioned him, he didn't tell me that. If I'm wrong, let me know. But when I asked him what the issue was, he said his grandfather was passing,
Yes.
and he said he left a telephone message with probation saying that his grandfather was passing. That was what he told me what was going on in his life. Is there something that I did not hear?
No, I'm sorry, Judge, and you're correct. It's just that when we were having our conversations there, we did go over that, Judge, and he did mention that, Judge. And I'm sure Josue is nervous, Judge. He understands the punishment that you can potentially give him. He's never been to the state jail facility. He's never even been to a prison. He's 20. I'm sure he's nervous, Judge. But nevertheless, he did tell you he did call. He was on the record, Judge, and that is accurate.
All right, so his previous criminal history,
Yes, Judge.
it's always dismissed, defendant convicted of other, dismissed, defendant convicted of other. And that's the harboring a runaway from
Correct.
County Court 8, dismissed, defendant convicted of other. Theft of a firearm, dismissed, defendant convicted of other. Another theft of a firearm, which I'm assuming occurred at the same time based upon the cause number, dismissed, defendant convicted of another. County Court 8, unlawfully carrying a weapon, defendant dismissed, defendant convicted of other.
Correct, Judge.
Possession case, dismissed, defendant convicted of other. Then he had the evading arrest or detention. He was sentenced, probation revoked. And then the possession of marijuana, dismissed, defendant convicted of other.
Oh, look at the defense attorney. The defense attorney wants her to stop so bad. Like, I know, I get it. I get what you're saying. I get what you're saying. I read it too. Just please stop reading it on the record. We don't need it on the record. He wants to interrupt so bad.
But it doesn't appear that he's learning anything.
Well, Judge, I think all those cases, I think either they were all within an incident or within a time frame, Judge.
Yeah.
But since he's been placed on probation, Judge, which is about 2 years ago, he has not picked up any new number ones, Judge. He's had difficulty balancing probation, like as you mentioned. He obviously took on other responsibilities that maybe he shouldn't have, but he hasn't picked up any new charges, Judge. He hasn't been out there causing problems to the community, maybe doing damage to himself by not obviously following the conditions that he was required to do. But nevertheless, Judge, he's not out there picking up new charges. As I had also represented him back then, told him, hey, you cannot be doing this. You're too young for this. You had also warned him as well when he first got on probation, Judge. So I know it's been a challenge for him. But he's eager to get this behind him, Judge, and take responsibility. And he is aware that you can punish him, up to the max, which is 2 years, Judge. We hope that that's not the case. But nevertheless, Judge, what he's told you here today, like you mentioned, the phone call, it did occur. And I know it's not reflective of the type of person he is on the MTR that you have in front of you, Judge, but we're hoping that you would consider following the recommendation and allowing him just to try to move forward, Judge.
Did you obtain your GED?
No, ma'am, I'm actually trying to get it right now.
No. You've been on probation with the court for 2 years. Well, minus 3 days. Did you obtain your GED?
No, Your Honor.
Did you obtain a certificate from a trade school?
No, Your Honor.
Did you complete the MRT program?
No, Your Honor.
So basically, you haven't done anything. You didn't really report all the time you were supposed to report. The drug testing levels haven't been the best. It's riddled with failures to submit positive. And then you would have 3 months of negative. Then you come back with dilute, fail to call, fail to submit, dilute. And then you'd have some negatives. Then again, it would be fail to call, fail to submit, fail to call. So this is where we are, and this is what I will do. You have a choice. Here are your choices. I'll send you to the state jail facility for 18 months, or either you can stay on probation and complete this probation, and you're going to be extended for 2 more years. And I will tell you, the only reason why I'm considering extending it for 2 years is because somebody has thought that you.
A diluted test just means you chugged a bunch of water before you tested. So the sample was so diluted they couldn't test it, which I agree and disagree with that, because people can do that and try to get away with a positive test. But I've seen some roofers going through probation and getting violations. I mean, they're roofing in the middle of the summer, so they're drinking a ton of water and they're doing diluted tests. So sometimes it makes sense why it's diluted, but yeah, generally a diluted test means you're trying to hide something, so you're chugging a bunch of water.
You're a great catch. You now have a 1-year-old, 2-year-old, and 3-year-old that somebody decided that you would be the perfect father. So those are your choices. 18 months in the state jail facility, or either you're going to be extended for 2 years on this probation.
Okay.
Extend me, Your Honor.
All right, court is going to deny the motion. Alter and amend conditions. Extend for 2 years. There's going to be the UA hotline.
Your Honor, if I may I have the sweat patch again?
No. Here's the thing. You were looking at going to the state jail facility, potentially for 2 years. We can go off the record. I don't know what's happening with society, what we're in. There used to be a saying that beggars can't be choosers. Now everybody who's begging want to choose. If somebody is standing on the corner and they're trying to get money from you because, I'm out of work or this is happening, and you want to give them $2, well, that's not enough. If you want to offer somebody food, well, you know what? Thank you so much for the chicken, but I prefer steak and lobster. You were looking at going to the state jail facility because you've done horrible on probation, and now you're trying to tell me what you prefer. Do you understand?
Yes, sir.
All right, we can go back on the record. It's going to be the UA hotline until further notice. You need to get employment. So is the mother of these 3 children working?
Yes, she's actually running the business that I have right now.
Running what business?
She's working with my father.
And what does your father do?
He sells tacos.
Sells tacos?
Yes, ma'am.
And who watches the children?
My mother.
People just out here having children and wanting their grandparents, the children's grandparents, to be mothers and fathers. They're not supposed to be doing that.
All right, I want to take you back about 5 minutes to what he said to Judge Boyd. He said he took is it his girlfriend, fiance? I don't know. He took her previous children, under his wing. Yet he's not working, living at his parents' house, while his girlfriend, fiance, whatever she is significant other is working for his parents. Like, no, you didn't take them under your wing. Your parents took all three of them under their wings. You didn't do anything. All right, I wanted to make sure that was known. Make sure everyone else realized how he messed that up.
Here's the thing, when you have a child, guess what? You're supposed to be figuring out what daycare is going to be, how much they're going to cost. It shouldn't be built in. Oh, my grandparents will watch the children. That's what y'all are supposed to be doing. Instead, y'all are playing house out here, just having a bunch of children. I can't even imagine taking care of a 1-year-old, 2-year-old, 3-year-old. The 1-year-old is in diapers. The 2-year-old is most likely in diapers. And since you all are not being good parents, the 3-year-old is probably in diapers, and nobody's talking to the children to educate them. They're just running around doing whatever. And then they end up going to preschool maybe, or going to school, and nobody has taught them anything. And they go to school and they want the teachers to be a parent to the children, which they're not supposed to be. Newsflash, teachers are just supposed to be educating your children. They're not supposed to be at the school teaching them values. That's supposed to be your job. And neither you or the mother are doing any of that. Y'all are just laying around having a bunch of children and passing it on to the grandparents. And you're going to get a job. And it's not going to be selling tacos, because there are only so many tacos that you can sell in San Antonio. Everybody here has a taco stand. And unless you're bringing something unique with your tacos, nobody's going to try to find you or find your parents and say, let me get tacos from this person. You understand? And are you all living on government housing?
No, we are.
All right, that's a good thing. All right, so there's to be a hotline until further notice. You are either going to get your GED, or you're going to get a certificate for some type of trade school. Welding is great. Being a plumber is great. So you can do any of those things. Go look it up. They have it at St. Philip's. They have it everywhere. Find you a lucrative trade, because guess what? If the 1, 2, and 3-year-old decide to go to college, prices when they get ready to go to college is going to be outrageous. You're looking at a mortgage. For that 1-year-old, it's probably going to be $200,000 to send them to college. And all of this thing where you're just going to undergrad, where you're just getting your BA, that is not even enough anymore. Just getting your master's is not enough anymore. You understand? So GED or trade school. And we're going to restart intensive outpatient treatment with probation. And there's going to be 120 sober support meetings in 120 days. Parenting classes. And once he completes parenting classes, 100 hours of community service will be deemed satisfied. And once he obtains his GED or some sort of trade school certificate, 100 hours will be deemed satisfied. And the court is ordering 200 hours of community service restitution. So once you complete all of those things, then it will be deemed satisfied. And I'm going to want field visits 1 time per month for 4 months. And then thereafter at probation's discretion. And please tell probation to check on the children. Probation, is there anything else?
Already,
Yes. Is there anything else you need from the court to be successful?
No, ma'am.
All right, good luck to you.
Thank you.
Thank you, Judge.
God bless you.
have a seat.
All right. That was Judge Boyd. I think we might actually be going back to Judge Garcia. I think we are. I don't think I missed any super chat. Nope, I'm good. All right. Yeah. I really do think we're going back to Judge Garcia.
Heather Knowles?
Yep, I am. You know, this is becoming one of my new favorite judges. And she does a lot of civil cases, which I enjoy civil cases. So that's why I watch her a lot.
And on this side, and an Angie Codwell on this side. All right. you want to go ahead and get us started? What is the monthly rent?
Sure, Judge. So again, there is no monthly rent in this case. You recall, I brought you a similar case about a couple months ago, same parties.
And yeah, I knew they looked a little familiar.
Yeah, it's a simple case of a probate. The owner of the property that Miss Ford is occupying has passed away. I brought both my client, who's a partial owner, and I've also brought the Eric Gregory, who is the executor of Helen Gregory, who is the owner of Helen Gregory's passed away, and his attorney has deeded the property over to the owners, which is my client, Cody Gregory, her brother, and Dave. Yeah, Dave. Dave has passed away, and nobody has probated his will, or we don't even know if there is a will, but we do have the heirs of his estate here as well. Basically, our position is, Miss Ford doesn't have a right to be there. We're not asking for rent. I'm asking for about $659.23 in attorney's fees and bare possession. That's our position, Judge.
Okay, so Ms. Ford, again, do you have any legal interest in this property? Legal interest in this property?
Dave and I had a lease agreement.
Okay, do you have that with you? Is it still valid?
Yes.
Okay. What is the reason that you haven't evicted? Because you have all the heirs here that are the owners of the house that don't want you there.
Well, Dave and I had a lease agreement that he wanted, because of what happened over at his brother's, he said I could stay at his mom's and fix it up so that he could sell it. He did not believe that Heather and Cody had any right to the property since Chris passed away before the title was transferred over. So it was only supposed to be in Dave's name only. And so that he was in the middle of trying to contest that and everything. When he passed away, he was hiring a lawyer to have that contested.
And who was this against? This lease, you and David?
Yeah, me and Dave.
When did Dave pass away?
4/25. And the day that he passed away, they came to collect his truck, and had me arrested for a traffic ticket, and then proceeded to enter the home and remove most of my belongings from the home. They even took the water heater. They put a padlock on the water meter. They took the refrigerators. They took the dryer. They took like most of everything that I owned out of the house, claiming that it was Dave's when they knew it was not. And then told me that hopefully you got receipts and you can prove it in court. After I was body slammed on the ground by Stephen Gregory for no just reason, saying that I had a felony fraud warrant, which is not true. Heather was there, and
okay,
her husband, and the whole, they called like 20-30 people and just cleaned my house out of all my stuff.
All right, so I've looked on the Bexar County tax appraisal, and it'll let me know who the owner of the property is. And right now, with the tax assessors, we have a Gregory, and a Heather and a Cody Notes as the owners.
Yeah.
So right now, when
This may have been on the same day of the last clip I played of Judge Garcia. I don't know. So that may be what you're talking about, but no. We're looking at the really small court picture in the top right. You can barely see the defendants or the people in court. You can barely see them. That's who we're talking about right now. Or that's who is in this hearing.
did you give the notice to vacate, counsel?
We gave the notice to vacate on May the 2nd, Judge. We ended up posting in a conspicuous place on the door.
All right, so again, counsel, I'm gonna go ahead and let you see this. This is,
And that was Dave's idea to make sure that what happened to me over at Chris's did not happen again, because he knew it wasn't right the way I was thrown out at the last property. So he wanted to make sure of that. And
Well, Judge, I'm going to object to this, is that we don't really have any proof that Dave actually signed this. I mean, I would suggest that Miss Ford get a handwriting expert. I mean, or have a representative of his estate testify and prove this up. And as far as I know, she could have just wrote this herself. Your Honor, I do have 2 certified deeds here, a distribution deed for the estate of Helen Gregory offered to Dave, who she's talking about, and Chris Gregory, who is the father of Heather and Cody, and Heather's deed where she's deeding to herself and to Cody. And they reflect what you read in Bear County CAD. I mean, even assuming arguendo that they had a lease agreement, I mean, it's up. I mean, we're the owners and we want her out.
All right, so Ms. Ford, my question to you is how quickly can you move out?
Well, my truck is not running at the moment, so it's to be able to get my things and to move out. It would take probably at least 2 weeks to be able to get the truck up and running and move the stuff that I do have left out of the house.
And counsel, what happened with Ms. Ford's first case? Was it dismissed here or was there a judgment rendered?
There was a judgment, Judge.
And so why wasn't that executed?
We didn't know, it's a different property, Judge.
Okay.
It's not the same, it's not the same.
Got you.
Yeah.
Okay.
We enforced that judgment. Judge.
Okay, all right. All right.
Sorry, I
so-
should have made that
No,
clear.
yeah, I guess I should have asked too. Counsel, Ms. Ford is asking for 2 weeks. Is that something you're willing to give her? Or you're seeking judgment today?
Seeking judgment.
All right, so Ms. Ford, unfortunately, I can't force them to give you that amount of time. They are the owners. I have looked it up under BCAD. And as far as the notice to vacate, it has been given. And as far as the lease is concerned, again, I don't know who wrote that lease. It could have been written yesterday. It could have been with Dave. I don't know. But at this point, they are the new owners and they have given ample time for you to move out and you are still there.
What about them removing the water heater and putting a padlock on the water meter and stealing all of my stuff from in the house? I mean, they knew they were not supposed to go in that house.
And you can go right out there and you can go pay to file a case and you can sue them all day long and I will entertain it at that time, but you are not going to piggyback on their case.
But isn't it like the law that says that they still have to stand by the lease agreement that somebody has, even if someone passes away or the property is sold to a new person?
And that is,
They
we're
still have
not,
to honor that?
we're not disputing it. First of all, they've given you the notice to vacate, which allows them to break that lease. And second of all, we haven't even authenticated that lease to begin with. It is a handwritten lease. And there is no proof that Dave, unless you can get somebody here to testify on, what is it, Dave's
Yes.
behalf, that he legitimately signed that lease.
I can do that,
Okay, and by when?
like today.
And who are you bringing in?
Mama Sherry, and she
And
was right
who
there.
is
She heard,
Mama
she heard,
Sherry?
she heard him say it. She's heard Chris say it. I mean, she was there. She was with one of their friends and that had
Who
communicated.
is Mama Sherry in all of this?
She was one of their friends that knew both of them. She grew up, she's part of their family, actually. She's cousins to them, to this family. She's a distant cousin. And so, I mean, so for their own family to sit here and confirm what I'm saying, she had conversations with them. She
Okay,
knows
and
this.
so let's say for argument's sakes that the lease is valid. They've given you a notice to vacate. Just because a lease is valid doesn't mean that they have to continue the lease. There are different regulations that they have to abide by in giving you a notice to vacate, which they have done properly. Okay, so at this point, even if the lease was valid, they have still given you the notice to vacate properly, and they have still given you ample time to move out. And at this point, we're still giving you an additional 5 days to move out with this judgment. So at this point, Ms. Ford, they don't want you there. Okay, unless you have a legal reason and an interest to be there that I can entertain, then I have to proceed forward. By law, it's not my choice. Okay, unless you can give me a legal reason to stop this eviction.
We'll proceed with small claims.
Judgment's gonna be for possession only, and attorney fees are gonna be in the amount of $500. Thank you.
Thank you, Your Honor.
Thank you.
All right, I think we're going to the last case of the evening. I don't remember what it was. Hold on. Oh, yeah. Okay. Yeah, this one. Let's have some fun with this one. But yeah. I don't know if this is MH or if she's just extremely confused. Hi, Heather. Heather's texting me. Yeah, this is an interesting one. She is so confused though. All right, let's go.
Rendon. And it is case number, it's Alyssa Amanda Rendon, 480303017. Ms. Rendon is adamant that she does not want the public defender to assist her in her case. I tried to go over the form with her, but was not entirely successful based on her not wanting me to represent her.
So Ms. Rendon, I can't allow you to represent yourself just because I may have to make certain findings that you're doing so knowingly, voluntarily, and intelligently. And that's why we have this form. I think Mr. Ainati was just trying to be helpful because otherwise now we're gonna have to do it live in court.
Okay. Is there any way to have another court appointed attorney?
So right now you have 0 attorneys appointed to, oh, you do have Stuart McNichols. So are you saying that you have an issue with Ms. Ainati?
Well, when this all happened, I didn't expect it to happen with an iPad and stuff, close to what was going on. I was thinking that I would, show up to court, or they leave me with some kind of like phone number to contact a court-appointed attorney.
And we gave you all that was.
But instead, they just gave me the iPad with this, so I got confused because I didn't think it'd be on an iPad.
So when you were in court,
I think that's what's confusing me.
When you were in court, when you were in when you were in court in March, Mr. Ainati's firm was appointed to represent you. SCORE should have given you all your paperwork before you left. And that would have had contact information for Mr. Ainati's firm on it. You also had a hearing on April 16th, and then you failed to appear. You didn't come to court.
Okay. Yeah, what happened with that was just that I forgot about it.
Right, so I hear you blaming a lot of other people for things and then saying—
I'm actually not trying to blame anybody. I just said that when I first got arrested and I came here and they told me I had court, they gave me an iPad and they had me talk to the person.
Just like I was in right now.
Well, yeah, I was in my jail cell, so I got really confused about what was going on. And then they let me go. And so then they did give me paperwork, but I had forgotten it in my cell. So if all that stuff was on there, I forgot it. So now I'm here again because they arrested me for a warrant and said that I missed court. So I get what you're talking about. I'm saying that I want, if there's any way to get a different court-appointed attorney.
And I'm asking you why.
Because I would prefer if I had a different court-appointed attorney, and then.
Why?
I just would prefer a different court-appointed attorney.
Unfortunately, that's not a legal basis to change attorneys.
Well, I didn't pick him, so I don't. It's not even about picking him. I don't know. I was just confused with that. It was in my cell that he came.
You have a right to have an attorney appointed to your case. You don't have a right to choose your attorney.
I get that. I get what you're saying. I missaid what I was saying. I thought I would be able to change it if I wanted to.
Mr. Ainati,
I don't know. I'd have to find a way to contact somebody. I don't know if they're gonna give me paperwork when I leave. I'll have a different number on there for me to call. I haven't called anyone yet. I don't have a cell phone, so that does make it challenging for me, which is not your guys' fault. I'm not saying that. I'm not trying to blame anyone for any of that.
Ms. Rendon, you have to come back to court because he was at court and he could have talked to you and helped you with whatever you needed. That's the whole point of having another court date, so you can have a chance to talk to your attorney if you can't get a hold of him in between.
Okay.
I don't have a conflict. And when I spoke to her, she just indicated that She didn't indicate that she wanted someone else. She just indicated that she, and I went over as explaining representing herself. So, my intent today, based on our conversation, was just to argue conditions of release because it did not sound like she had any desire to try and resolve the case today. But she, as she has explained, why she missed court.
So I'm going to ask you one more time, Ms. Brendan, why you want a different attorney.
I don't know, I just didn't think that I don't know that I don't even know. I just thought I could maybe choose someone else to get a different kind of like perspective from someone else was what was going on.
So an attorney's job is to tell you sometimes the hard truth, not the truth that you want to hear. And I just don't hear you giving me any reason to remove Mr. Ainati or his firm.
And that was my only reason, just to
you have a right to represent
like talk to somebody else about it. Okay.
I need to know how we're proceeding.
Well, I did say I didn't want one, but then they said that.
I think we're just asking the court to address the conditions of release. And set another date, Your Honor.
And I guess I'm very confused as to what Ms. Rendon wants, other than she wants to talk to someone else, but I hear no basis for that. And that can't happen today. There is no one else today. Ms. Rendon, I'm confused about how you would like to proceed.
I would like to talk to someone else. I need to look at the.
I feel like you're not listening to me. There is no one else available today. So if you want to talk to someone else, that pretty much means staying in jail until tomorrow.
Okay. Well, I don't know what to say to that other than I did think I was gonna get out today, but I don't know.
All right. I have no idea what to think about this. I really don't. Again, I don't think it's MH issues. I don't know. I have no idea. She's not listening. She's not paying attention. No idea what's going on. I have no idea what's going on. She has no idea what's going on. You know what? No one in the courtroom has any idea what's going on. You guys don't know what's going on. So this is just confusion all around. Thank you so much, defendant, for confusing everybody that's watching. All 274 of us right now. All right. It's almost time to let this play out because this video is almost over.
Let me just start at the beginning then. So today is a pretrial hearing. You were arraigned at your last hearing in custody. I appointed Mr. Ainati's firm to represent you, set conditions of release, and gave you another court date. Okay? Then you didn't come back to court. A warrant issued because you didn't come back to court and you didn't call us and let us know what was going on. I mean, like, for example, that your car broke down and couldn't get here or something. And I've heard you just say that you forgot about it. You currently have a warrant out of King County District Court as well. So today is a pre-trial hearing, which is sort of when you decide how you want to start beginning to decide how you want to handle your case, whether you want to take whatever the city's offer is or continue it, argue for release, and set an out of custody hearing. Those are the kind of things that can happen today. And I don't know sort of which road we're going down.
Oh. So if I got the time to call to ask someone to talk to another court-appointed attorney, what information would I be given to like call that person to contact them? Because
So you
that's
haven't,
what I'm wanting.
Ms. Rendon, you haven't given me a basis to remove Mr. Ignati from your case. I don't know why you want to talk to someone else. What you think is going to be different if you talk to someone else.
I don't know. I wouldn't know until I talked to the other person.
Okay. And as I've told you today, there is no one else. Mr. Ignati is the only attorney we have available.
Yeah, I just don't feel comfortable with the iPad and all that stuff. I don't know why there's an iPad involved and all that. It's really strange to me.
Okay, so regardless, even if I was able to get another attorney, that attorney would be on an iPad today because you're in custody.
Why is everything on an iPad though? Why can't it be like that I just talk to a regular person here and have court and then I'm gone?
Because
the last time I talked to that lady, I forgot it. I get that I have warrants, I get that, but I'm trying to ask you about just not being on the iPad.
And I understand that it's not what you expect, but today that's what's available, given the timing of other things going on in our court. This is not the only case we have today.
I get that.
Okay.
Something tells me she doesn't get that. I don't think she understands anything that's going on right now. All right, I'm going to let this video play out. You guys have been awesome. Thank you so much, everybody, for the super chats, the PayPals, the likes, the gifted memberships. You guys are all awesome. Hope you guys have a great rest of the night. Keep the party going in Discord after this. But this is all I got. This is all I got. So I will see you all either in Discord or tomorrow. Until next time. Bye.
So are you just asking for the court to release you with a new court date today?
Sure.
Okay. What is the city's position?
City is requesting that they'll remain a 500 cash for bond. City believes the defendant's a high risk of future failures to appear based on the factors the court already stated. Failed to appear for out of custody pretrial after being released with actual notice. She has an active warrant out of Pierce County District, King County District Court.
What is Mr. Ignati?
Hey, I don't have any additional information beyond what was said by Ms. Rendon. That it sounds like her paperwork, she didn't keep the paperwork and forgot to contact the court. She said she did resolve of the warrant initially out of the other court, but it looks like they reissued the warrant. And so she's aware that she has that warrant and plans on taking care of that warrant as well.
The problem is you've had 2 failures to appear on your King County case. Is she held on that?
Okay.
It doesn't look, I can't tell based on their docket whether they've addressed it yet.
Yeah, I can't tell either. I'm going to maintain, are you going to have time to go to the court, to the jail tomorrow?
I'm hoping that I will, yes.
I'm going to maintain bail in the amount of $500. We'll set this over till tomorrow. Today's commencement's the first appearance after a failure to appear. Probable cause was previously found on March 27th. Bail remains $500. Okay, we'll see you tomorrow, Ms. Rendon. And Mr. Ignati just said that he's hoping to get to the jail so we can talk to you in person.
Don't be over an iPad. Yep, I'll talk to you in person tomorrow.
All right, thank you, ma'am.
Okay, bye.